Upon the other hand, where a statute of Louisiana required those engaged in the transportation of passengers among the states to give to all persons traveling within that state, upon vessels employed in that business, equal rights and privileges in all parts of the vessel, without distinction on account of race or color, and subjected to an action for damages the owner of such a vessel, who excluded colored passengers on account of their color from the cabin set aside by him for the use of whites. It was held to be, so far as it applied to interstate commerce, unconstitutional and void. Hall v. Dagwer, 95 U.S. 485. The court in this case, however, expressly disclaimed that it had anything whatever to do with the statute as a regulation of internal commerce, or affecting anything else than commerce among the states. In the civil rights cases, 109 U.S. 3 Supreme Court Reporter 18, it was held that an act of Congress entitling all persons within the jurisdiction of the United States to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of public conveyances, on land or water, theaters, and other places of public amusement, and made applicable to citizens of every race and color, regardless of any previous condition of servitude, was unconstitutional and void. Upon the ground that the 14th Amendment was prohibitory upon the states only, and the legislation authorized to be adopted by Congress for enforcing it was not direct legislation on matters respecting which the states were prohibited from making or enforcing certain laws, or doing certain acts, but was corrective legislation, such as might be necessary or proper for counteracting and redressing the effect of such laws or acts. In delivering the opinion of the court, Mr. Justice Bradley observed that the 14th Amendment does not invest Congress with power to legislate upon subjects that are within the domain of state legislation, but to provide modes of relief against state legislation or state action of the kind referred to. It does not authorize Congress to create a code of municipal law for the regulation of private rights, but to provide modes of redress against the operation of state laws and the action of state officers, executive or judicial, when these are subversive of the fundamental rights specified in the amendment. Positive rights and privileges are undoubtedly secured by the 14th Amendment, but they are secured by way of prohibition against state laws and state proceedings affecting those rights and privileges, and by power given to Congress to legislate for the purpose of carrying such prohibition into effect, and such legislation must necessarily be predicated upon such supposed state laws or state proceedings, and be directed to the correction of their operation and effect. Much nearer, and, indeed, almost directly in point, is the case of the Louisville, New Orleans, and Texas Railway Company v. State, 133 U.S. 587, 10 Supreme Court Reporter 348, wherein the railway company was indicted for a violation of a statute of Mississippi, enacting that all railroads carrying passengers should provide equal, but separate, accommodations for the white and colored races, by providing 2 or more passenger cars for each passenger train, or by dividing the passenger cars by a partition, so as to secure separate accommodations. The case was presented in a different aspect from the one under consideration, inasmuch as it was an indictment against the railway company for failing to provide the separate accommodations, but the question considered was the constitutionality of the law. In that case, the Supreme Court of Mississippi, 66 Mississippi Reports 662, 6 Southern Reporter 203, had held that the statute applied solely to commerce within the state, and that being the construction of the state statute by its highest court was accepted as conclusive. If it be a matter, said the court, page 591, 133 U.S., and page 348, 10 Supreme Court Reporter, respecting commerce wholly within a state, and not interfering with commerce between the states, then, obviously, there is no violation of the Commerce Clause of the Federal Constitution. No question arises under this section as to the power of the state to separate in different compartments interstate passengers, or affect, in any manner, the privileges and rights of such passengers. All that we can consider is whether the state has the power to require that railroad trains within her limits shall have separate accommodations for the 2 races. That affecting only commerce within the state is no invasion of the power given to Congress by the Commerce Clause. A like course of reasoning applies to the case under consideration, since the Supreme Court of Louisiana, in the case of State v. Judge, 44 Louisiana Annual Report 770, 11 Southern Reporter 74, held that the statute in question did not apply to interstate passengers, but was confined in its application to passengers traveling exclusively within the borders of the state. The case was decided largely upon the authority of Louisville, New Orleans, and Texas Railway Company versus State, 66 Mississippi Reports 662, 6 Southern Reporter, 203, and affirmed by this court in 133 U.S. 587, 10 Supreme Court Reporter 348. In the present case, no question of interference with interstate commerce can possibly arise, since the East Louisiana Railway appears to have been purely a local line, with both its termini within the state of Louisiana. Similar statutes for the separation of the two races upon public conveyances were held to be constitutional in Railroad v. Miles, 55 Pennsylvania State Reports 209, Day v. Owen 5 Michigan 520, Railway Company v. Williams, 55-3. 185, Railroad Company v. Wells, 85 Tennessee 613, 4 Southwestern Reporter 5, Railroad Company v. Benson, 85 Tennessee 627, 4 Southwestern Reporter 5, The Sioux, 22 Federal Reporter 843, Logwood v. Railroad Company, 23 Federal Reporter 318, McGuinn v. Forbes, 37 Federal Reporter 639, People v. King, New York Court of Appeals, 18 Northeastern Reporter 245, Howe v. Railway Company. 38 Federal Reporter 226, Hurd v. Railroad Company, 3 Interstate Commerce Commission Reports 111, 1 Interstate Commerce Commission Reports 428. While we think the enforced separation of the races, as applied to the internal commerce of the state, neither abridges the privileges or immunities of the colored man, deprives him of his property without due process of law, nor denies him the equal protection of the laws within the meaning of the 14th Amendment, we are not prepared to say that the conductor, in assigning passengers to the coaches according to their race, does not act at his peril, or that the provision of the second section of the Act that denies to the passenger compensation and damages for a refusal to receive him into the coach in which he properly belongs is a valid exercise of the legislative power. Indeed, we understand it to be conceded by the state's attorney that such part of the act as exempts from liability the railway company and its officers is unconstitutional. The power to assign to a particular coach obviously implies the power to determine to which race the passenger belongs, as well as the power to determine who, under the laws of the particular state, is to be deemed a white and who a colored person. This question, though indicated in the brief of the plaintiff in error, does not properly arise upon the record in this case, since the only issue made is as to the unconstitutionality of the act, so far as it requires the railway to provide separate accommodations, and the conductor to assign passengers according to their race. It is claimed by the plaintiff in error that, in an mixed community, the reputation of belonging to the dominant race, in this instance the white race, is property, in the same sense that a right of action or of inheritance is property. Conceding this to be so, for the purposes of this case, we are unable to see how this statute deprives him of, or in any way affects his right to, such property. If he be a white man, and assigned to a colored coach, he may have his action for damages against the company for being deprived of his so-called property. Upon the other hand, if he be a colored man, and be so assigned, he has been deprived of no property, since he is not lawfully entitled to the reputation of being a white man,